welcome to criminal proceedings week 2. Basically, like the way we dealt with in term 1, we are dealing with trial in the magistrates courts. So we have since left the trial in the chief magistrates and magistrates courts, and now we are moving to proceedings in the High Court. So we're going to be looking at proceedings in the High Court. So important to note that if you understood what we learned last term, then of course this term also is going to become very easy, because we have a few different principles, but the others really stay the same. So this module will equip students with skills required to manage and conduct trial proceedings in the High Court, specifically encompassing unique aspects such as preliminary hearing and participation of assessors during the trial. So basically we shall look at preliminary hearing, where we shall look at committal proceedings. And I think you have seen in most cases, for example, the Obed Nasser case, and also in cases of Bubu Wine, whereby the chief magistrate has only read his or her charges. So the chief magistrate will only read your charges and then say, I don't have jurisdiction to hear this case, I have therefore committed it to the High Court. So basically that's what we call committal proceedings. So in committal proceedings, the accused basically comes to the chief magistrate, who only reads the charges and then commits him to the High Court. So we shall see the role of assessors. Remember, we have the assessors rules, which basically governs these assessors. But assessors are always in courts, basically in the High Court, and they are supposed to also, the judge is supposed to summarize to them the case, so as he can hear their opinions. However, what is important to know is that the opinion of assessors is not binding to the court. Of course, this should be distinguished from the American system, where we have what we call the jury, and I think the assessors basically play the role what the jury play in the American criminal system. So we shall be looking at assessors, whereby we see that under the rules, the assessors rules, every High Court proceedings must proceed with at least 2 assessors. So where we don't have these 2 assessors, it also becomes a ground of appeal. But we shall look at appeals when we get to term 3. So the skills for the above procedures will be imparted to students through demonstrations. Students will be taken through the entire process from alignment to sentencing. So let me hope that we still have the other newspaper article by the judge, which basically takes you the process of criminal trials from alignment to taking plea, to submission for no case to answer, to submissions, and after that to sentencing, and then mitigating and aggravating factors, and then the final judgment. You have to understand that chronological order, because it becomes very easier for you to pass the oral exam. So scope of the week's work: 1, preparation of legal memorandum advising the DPP and giving directions to the police. I'm very sure that we looked at the role of the DPP, basically where we are proceeding under Article 120 of the Constitution. So still now it's the same role to advise order for investigations, to withdraw, all those roles we looked at. The drafting of relevant court documents for the trial process in the High Court. So important to note that whereas in term 1 we are dealing with charge sheet, here in the High Court we have the indictment. So please don't make a mistake of referring to a charge sheet. Charge sheet stop in the magistrates courts. So as far as we go to the High Court, then we have what we call an indictment. So the prosecution and defense of the homicide case before the High Court. So when we talk about homicide cases, we are looking at cases that involves the death of an individual. For example, murder, manslaughter, those ones, that's what we call homicide, cases that involve the killing of an individual. And it's important to note that these cases are tried by the High Court. The illustration of the exercise of the powers of the registrar of the High Court. So basically, the registrar of the High Court has powers like those we shall be looking at in this workshop. For example, a revision, he can revise. So illustrate DPP's powers in the exercise of prosecution, discretion, and conducted trial as a High Court judge. So we shall be looking at the exercise of the DPP powers under Article 120, as well as how do you conduct a trial when you are a judge. So the aims of the workshops are to, one, develop skills relevant for the institution of cases before the High Court. How do you institute cases before the High Court? We have said it's an indictment, but remember there also must be committal proceedings. Of course, committal proceedings have been arranged in the case of Sam Kutesa versus Anthony General. Because I think it's a wastage of time. Why should you go and hear committal proceedings in the court where there is no jurisdiction? And now for what purpose? Doesn't it contravene Article 28 for the fair hearing? Because still, even if you apply to bail, the judge will tell you that the Chief Magistrate's Court will tell you that I don't have jurisdiction to entertain that matter. So develop skills necessary for the management of trial processes before the High Court. So how do you manage trial processes before the High Court? We shall see committal proceedings, but also there is pre-taking and also submissions for no case to answer. Then develop skills for the trial of homicide cases before the High Court. Develop skills necessary for the institution and prosecution of the bail application before the High Court. So we shall also apply for bail, and of course the grounds are the same like the one we looked at before the magistrates courts. Then identify ethical issues. Of course, you must ensure that you represent your client in time and make due diligence, and also apply for bail. All those remedies which are vital to the accused. So we shall look at the appropriate registration. Of course, Article 23, which provides rights to liberty. Article 28, right to fair hearing. Article 120 on the powers of the DPP. Article 129(1) on the courts of judicature in Uganda, and Article 212 on the I think talks about powers of police, and then 250 sub Article 4. So we shall look at also the Judicial Act along with the trial indictment, and also other statutes. But important to note is the Seufu Muhammad versus Uganda. You know, this case, he was at Pine. He was a businessman at Pine, selling cars, and whereby some lady from Kasese had bought a car from him. Then he had failed to pay the balance, so they tortured him until this person died. So it's a case on murder. Of course, we have very many cases on murder. We have Welansenga versus Uganda. So those cases clearly bring out all the ingredients of murder, to include the death of the person, that the death was caused by the accused. So there was causation, and it's the accused who caused the death. So basically, those are some of the ingredients of murder, and you have to look at also the Penal Code Act. So we have a case file here, Uganda versus A1 Mango Hassan, as well as Bwaratamu Octavius. So it's Uganda Police Form 2B. Katwe Consulate, 37 years, businesswoman. So they're saying that the above are my particulars. I wish to state that on the morning of 23rd 10th 2024 towards 3 a.m. I and my husband Mugaria were woken up by some noise outside the house. We could not sleep, so my husband decided to move out of the house to check on the chicken which were making noise. When my husband went out, certain people who had invaded our home locked me inside the house using a bolt, and they then set up upon the deceased, hacking him with machetes and other objects, and left him lying on the ground. As he was being attacked, I kept shouting and also mentioning the names of the assailants. I made an alarm. My husband mentioned some names. He mentioned Mango and another person. I peeped through the keyhole, and I was able to see a certain man in the compound, and the aid of some from the neighboring home, and I described that to the police. So basically here you see we are looking at identification and the law governing identification. You remember, when you're looking at identification, you are looking at the time and the distance. So we shall be looking at now whether it was appropriate, whether the time was appropriate for the witness or for the wife to identify the accused. And the law on identification has been discussed in the Abdere Abdere case, Uganda versus I think Abdere. So it basically discusses the law on identification, whereby the court is saying that you have to look at the time, the source of light, as well as the distance, to ensure that the person properly identified, they are chosen. So at another part of the house and through the window, I could see the scene through the window. I kept watching and I was able to recognize the voice of Mango, whom I have known since childhood. He operates a border motorcycle within our trading center. He's a very talkative person and his voice is well known. Although I did not see him as it was dark, I heard him telling others to hurry and leave the scene as the deceased was finished. When they left, I gathered courage and went outside to look for my husband. I found my husband lying on a pool of blood. My neighbor Mukasa was in the compound with a panga. He told me that he had my husband wailing and he came running on for the silent free. I went to our LC1 chairman, who gave me a letter introducing me to the police, where I reported the incident and described the police to people I saw assaulting my husband. This is all I can state for now. So basically here we are dealing with murder. We are dealing with murder as one of the as one of the offenses. Then we also have the statement of the witness statement. Mukasa Aristotle, 51-year-old adult Muganda resident of Chugundu Zone, Makinde. The above particulars are mine. In the night of 24th, it was, I think, around 5 a.m. I had an alarm coming out of the deceased home. I ran there in response to the alarm. I had movements of people walking towards me. I was on footpath through a coffee plantation. I moved away from the footpath and hid in the coffee plantation, which was 5 meters away from the footpath. With the aid of some moonlight, I saw a bald-headed Baltamu and his colleagues on the footpath moving away from the scene. One person was carrying a panga, machete, and the other were carrying sticks and crabs. I heard them talking in self-praise and praising a man called Fire. I left them to pass while I hid, observing and breathlessly in the plantation. When I arrived at the home of the deceased in his dying moments painfully disclosed to me that was here felt as Kukwirata and his friend. So basically we are now looking at a dying declaration, because now you see this person is making a declaration when he's dying. So what we call a dying declaration. So we shall look at circumstances under which can you rely on a dying declaration, as we can see in this statement of the witness. So I remember about 3 months ago, the deceased had told me that his life was in danger because Mango had promised to finish him. I did not manage to see Mango because there were many. I discussed this threat with the LC1 of the area. So we are looking at statement of the investigating officer also. The above particulars are mine. I'm the investigating officer in this case. I wish to state that on the morning of 24th October 2024, at about 8 hours, Subuga located me a case referring that he had been reported. The case had been reported by a complainant called Nasenya Consulate against a certain Mango and others. From the descriptions, our intelligence and task team mounted a security swoop within the village, and we arrested certain suspicious men hiding and smoking marijuana in an incomplete house at Chiindi Zone. One of the men, Baratam, had the rest ran away, but we later arrested Mango and Baratam, who had requested Ginger since the incident, and the rest are still at large. So basically still at large means that they are still running, they haven't been found. But also here, remember, there is circumstantial evidence. How do you conduct yourself after the scene? Because if these people are innocent, now then why are they running away? Because this is going to be circumstantial evidence. However much it might not be conclusive, but court is going to look at it. If you say that you're innocent, then why were you running away? So I also immediately filed PF488A and PF booked out a case in mortuary, Mulago in the camp under the friends of the late Muganya, and on arrival, I introduced myself, the mortuary staff, and the reason for our visit. We are taken into inside and friend of the late known as Mukasa Soto, and find the body which had been caught with wounds to the head. I then handed over the P4 requesting for postmortem to be carried out. The details were registered and I was handed a carbon copy, with which I returned to the police station. I then took the suspect Bataram and Marago for medical examination. I took them on Naguru Hospital where they were examined, and we took them back to police cells. Both suspects were found to be of normal and sound mind. The injuries inflicted on the deceased as shown by the post-mortem that I recovered, the photographs of the body exhibited, that is what I can state. So basically here you are proving causation, that it was really this that caused the death of the victim. So suspect's plain statement that the above are my particulars. I know that deceased as my friend. There is no way that I can try to take away the life of the deceased. In fact, I reported the matter to the authorities. I'm just a victim of circumstances. I was not even in the village that night. So now the suspect brings what we call a defense of alibi, where he says that he was not in the village that night. I had gone to do some businesses in Jinja with my girlfriend, whom I usually meet in the street at Naraba. Yeah, Lord. I then returned. My wife knows that I slept at home. I am being framed by my enemies who are not happy with my success in business, not to know what happened to him. That is all I can say. So basically that's a statement of the accused. So basically we even have a medical examination report here, accused of the serious person, examination by medical officer. So this is the evidence you are going to be relying on. Remember, also have a post-mortem examination report, also pathologist Barimwayo Erika. So all this is the evidence we are going to be relying on. Remember how to prove our case beyond reasonable doubt. So basically the questions are here. Workshop task: assume that you are the resident chief asset attorney at Nakawa. By the end of the workshop, students should be able to 1. Produce a police file and 5 possible offenses disclosed and their ingredients. Basically we have disclosed murder, as well as there can also be conspiracy. This murder and conspiracy. Then draft committal documents in capital offenses. Draft committal documents in capital offenses. Draft necessary documents for a bail application before the High Court, and argue and oppose an application for bail in the High Court, and arrange a criminal session ready for hearings to commence. So assume that you are the resident chief Anthony at Nakawa, and the above file has been submitted to you by regional CID officer for perusal, and legal advice. Peruse the case file and do the following: identify the offenses, if any, disclosed by the facts, and evaluate the evidence in support of the possible offenses. So let me hope that we are now all masters of identifying offenses, but also evaluating evidence. Of course, we say that when you are going to identify offenses, you are guided by the, of course, the definition of an offense, the principle of legality, and then you can proceed to identify offenses, which one of them is murder. Then on evaluating evidence, you're governed by, of course, section 101 of the Evidence Act, who alleges must prove, the burden of proof and the standard of proof. You must first quote that, and then you proceed to evaluate evidence. And when you are evaluating evidence, you are looking at each ingredient of the of the offense. So in fact, evaluate the evidence. So in the event that you find the evidence sufficient, draft the necessary documents for possible trial in the High Court in the above. So we said there you draft an indictment. You draft an indictment. However, the art of drafting still remains the same, like the way we looked in term 1, drafting charge sheets. So 2, assume you are in the Chief Magistrate's Court and the Chief State Attorney informs court that the investigation inquiries in the matter are complete by overall play, have the accused persons committed to High Court for trial. So I was talking about committing. So in committal proceedings, basically the Magistrate's Court reads the charges of the accused and says, I don't have jurisdiction to try this matter. I therefore commit it to the High Court. And even if you apply for bail, he won't give you bail because he will still say, I don't have jurisdiction for this matter. I therefore commit it to the High Court. So assume that you are an advocate in private practice and you have been approached by the relatives of the accused person who is currently remanded at Zira government prison. Advise them on the remedy available to him in circumstances, if any. So basically here, that's why we would do what? We would apply for bail. You apply for bail, of course, you have seen the grounds. Of course, grounds being that he has a fixed place of abode, and also you have substantial securities, and we say that the documents would be notice of motion supported by an affidavit. But remember, you have to have substantial grounds maybe sickness, and you have fixed place of abode, as well as substantial securities. So assume that you are a chief magistrate and you have been served with the documents envisaged in 3B above, draft and necessary documents envisaged in 3A above. So they're saying that assume you are the chief magistrate and you have been served with the documents envisaged in 3B. Draft the necessary documents envisaged in 3A above. So I think basically here you want to oppose the what? The application for bail. You are basically arguing that the bail shouldn't be done what? The bail shouldn't be granted to the what? To the accused because of one, the crime being rampant. Of course, even like president is against granting bail. So you have to argue your case that this accused does not cannot be granted bail. So assume that you are in deputy registrar of the High Court and you have been redirected to arrange a criminal session. Then the practical steps you would take to successfully put one in place. So basically, we shall look at how do you arrange a criminal session if you are a registrar, from of course serving notices to both lawyers to arranging the hearing date, and basically how it's going to be conducted. So basically that's what we are going to be dealing with. So I think that's my analysis of the workshop. So please, if you want a detailed discussion where we give you cases, sections, as well as analysis of the IAs, the possible IAs, past IAs, to get you ready for the IA, you can join us. We have a mastermind group where members pay a monthly subscription fee to support our research. We're a team of 8 lawyers who will basically be preparing you for an oral exam, and it's an online program, so we have students from all the 4 campuses. So in case you are interested, please, there is a WhatsApp number on this on my YouTube channel. Please text me, and then I will guide you and add you to that group if you can be able to afford that cost. But if you cannot, then of course this YouTube channel will also be important to you. So please like, subscribe, and share to your friends, so as many can benefit. So we are going to workshop 2. Preparation for the workshop. The groups designated by the firm leader must meet well in advance to discuss the workshop assignment and send by email the firm's proposed presentations to professional advisors assigned to them per the timetable. Each student shall conduct personal research and prepare personal notes with respect to all the tasks prior to the workshop. Failure to prepare may lead to a student being excluded from the session. Learning outcomes. By the end of the workshop, students should be able to peruse, analyze, and evaluate evidence assembled in homicide cases, institution of homicide cases before the High Court, manage the trial process as the judicial officer in the High Court, prosecute and defend the cases of homicide before the High Court, and identify the dilemmas that arise from the trial processes before the High Court. So case file number 2, facts and documents as in case file number 1. So the good thing here, we are using the same facts, so that's good. We are using the same facts for case number 1. So 1, assume that you are the chief assistant in the office of the ODP and the accused counsel informs you that his client is willing to enter a compromise without going through a full trial. Advise on the procedure of addressing the request. So basically here we shall look at how do you enter into a compromise in criminal proceedings, and we looked at one of such kind in term 1, where we are looking at pre-bargaining, and of course you can do what we call a pre-bargaining agreement, and it can also work here, because we are saying, assume that you are the chief assistant in the office of the ODPP and the accused counsel informs you that the client is willing to enter a compromise without going through a full trial. Advise on the procedure of addressing the request. So we look at the pre-bargaining rules. So assume the position of the judge of the High Court and you are commencing a criminal session with this case file. By way of demonstration, proceed to take and record a plea of not guilty and introduce the assessors in preparation to hear the prosecution's case. So basically here we looked at the process of taking plea as governed by the case of Adan versus Al. If in case you didn't understand that, you have to go back to the case of Adan versus Al. Of course, you must ensure that the accuser understands your language. Then after that, you read the charge in the language he understands, and then you must read the facts as well as all the ingredients, and then ask the accuser whether he or she understood the charge. Then after that, you proceed to enter what we call a plea of not guilty, and of course you must also introduce assessors in preparation to hear the prosecution's case. So we see the assessors, basically these are people who are always in the High Court, and they're supposed to also give guidance to the judge. They are always appointed. We shall look at what we call the assessors rules, which basically governed on the law how these assessors can be appointed. Assuming a state attorney appearing in court prosecute this matter after pre-taking, defense counsel informs you that he does not intend to object to the PF24 being tendered on court record as prosecution evidence. What procedure will you take to ensure the said PF is received on court record? So assuming you are a state attorney appearing in court to pursue this matter after pre-taking, defense counsel informs you that he does not intend to object to the PF24 being tendered on court record as prosecution evidence. So basically we looked at the procedure of tendering in evidence. When you're tendering in a document, of course you have to bring the person who authored it, and then do what? And then help him to describe the document, and then after ask court to admit the document as the exhibit of what? As the exhibit of the prosecution. But the fact that now here they were not the defense counsel want to be opposing, but still that's how you would still have to tender in that document through the person who authored it. Then 4, assume the role of a state attorney and by way of role play proceed to lead evidence of the complainant, Mukasa Isoto, and the pursuers and tender the auto posse. So basically here they want us to lead evidence of the complainant. Basically I want to cross-examine the chief Mukasa Aristotle, and also you tender in the report by the pastoralist. I hope that we looked at how do you do all this, how do you tender in document, and how do you cross-examine in chief your witness. So assume the role of the defense counsel by way of demonstration, cross-examine Mukasa Aristotle and the pastoralist. So now we're going to do what to do cross-examination. So we said first and foremost, examination in the chief is by counsel who brings the witness, and we said cross-examination is the opposite counsel now coming to pinch holes in your witnesses in your witnesses evidence. Then after that you're given a role to do what? The re-examination. So this is going to be very important in moots. You have to understand how basically you go about that, the process of examination in chief, cross-examination, as well as re-examination, because also they can ask you in orals to do one of those things, but it's really very easy once you practice it. So identify and address the ethical dilemmas arising from the scenarios. Of course, you must do proper due diligence. Secondly, don't act without instructions, but also make sure that you don't do what? You don't coach your witnesses in a cross-examination, and also making sure that the rights of the accused are not violated. The state attorneys should also be taking bribes. So basically, when we look at ethical dilemmas, we are governed by the Advocates Professionals Code Act, but also the Judicial Code of Conduct, because in case there is conflict of interest by the judicial officer or the state attorney, then also you must excuse yourself from the matter. So that's one of my analysis of workshop 2. I think it's not going to be a very detailed week because I see we have a brief workshop considering the fact that we are using facts for workshop 1 in workshop 2. So basically that is it. Please subscribe, like, comment, share, because this YouTube channel, the purpose of this YouTube channel is to basically make you pass the bar course. So it shall be a journey. We started it with you, and we promise that God willingly we shall end it with you, where we shall also prepare for oral questions up to the very end when we do examination. So it has been a very good journey from day one. Please subscribe, like, and share to your friends so as they can be part of this growing community. But also we have a mentorship program covering all campuses. So in case you want to get the notes from us, also online discussions on Saturday and Sunday, then you can contact the number on my bio. Then you can WhatsApp me and I'm going to guide you to be part of that mastermind mentorship community, where we help to look at past IAs and then prepare you to pass your weekly IA. So it has been a pleasure as well as a blessing. Please subscribe, like, comment, and share.